Hello everyone. Welcome back to our channel, US Immigration Reform. We hope you're doing great. In this video, we will discuss Trump's major changes in USCIS and green card processing times in 2025. After Trump's order, recent changes in U.S. immigration policy, including the suspension of the I-134A form and shifts in green card processing, signal a move toward more restrictive measures under the Trump administration. These changes are reshaping the immigration landscape, affecting family reunification and humanitarian parole programs. If you are interested in this, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell on upcoming video. So, without any further delay, let's jump into the video. Amid a surge in anti-illegal immigration operations, the United States Citizenship and Immigration Services has recently announced a temporary pause on an essential immigration form, following President Donald Trump's executive order on January 20th. This significant decision is part of a broader shift in immigration policy that aims to tighten controls and end certain immigration processes previously enacted under the Biden administration. The pause particularly affects the I-134A form, which is used in the humanitarian parole process and family reunification proceedings. The suspension is emblematic of the broader goals of President Trump's administration, which has focused on curbing illegal immigration and restricting pathways to lawful status for certain foreign nationals. Trump's executive order and its impact on immigration policy. President Trump's executive order, issued on January 20th, grants him authority over the Immigration and Nationality Act, 8 U.S.C. 1101 etc., and Section 301 of Title III of the United States Code, a legal foundation that has been pivotal in enabling various immigration actions throughout his presidency. This order asserts that the United States has suffered from what it describes as an unprecedented large-scale invasion of illegal immigrants. According to the order, millions of individuals from a variety of nations have entered the U.S. unlawfully, many of whom are described as potential criminals, spies, or agents of foreign governments with harmful intent. The rhetoric surrounding this order emphasizes a need to secure the U.S. borders and restrict the entry of individuals who are deemed to pose national security risks. Suspension of the I-134A form, a key element of humanitarian parole. In response to the executive order, USCIS announced the suspension of the I-134A online application to become a support person and declaration of financial support form. This form was central to the Biden administration's efforts to provide humanitarian relief to individuals from countries such as Cuba, Venezuela, Nicaragua, and Haiti. These individuals were granted parole status if they had a financial sponsor in the U.S. who met specific eligibility requirements. The suspension of the I-134A form halts the application process for humanitarian parole for individuals from these nations, directly affecting over 500,000 people who had been able to secure temporary status and support through the program. The pause of this form is directly linked to Trump's desire to dismantle programs that, according to his administration, run counter to U.S. policies. His January 20th executive order specifically called for the termination of categorical parole programs for citizens from Cuba, Haiti, Nicaragua, and Venezuela, which had been a central feature of Biden-era immigration relief. Under these programs, thousands of individuals were allowed to enter the U.S. for temporary stays based on humanitarian reasons, such as fleeing violence or persecution in their home countries. Family reunification and financial support, a dual impact. The suspension of the I-134A form has a dual impact, affecting not only those seeking humanitarian parole but also individuals in family reunification proceedings. The financial support document is used in both humanitarian parole applications and family-based immigration processes, meaning that families seeking to reunite in the U.S. are also affected by the USCIS policy change. For many individuals awaiting approval for family-based immigration petitions, this suspension means an indefinite delay in their ability to reunite with loved ones in the U.S. Furthermore, the financial support document is a critical component for verifying the ability of U.S.-based sponsors to support family members financially, without placing an undue burden on the U.S. government. Trump's immigration strategy, a golden age of restriction and deportation. The pause on the I-134A form comes as part of a broader trend within Trump's administration toward what some are calling a golden age of restrictive immigration policies. Since his inauguration, Trump has consistently sought to limit both legal and illegal immigration, often using executive orders and policy changes to reshape the landscape of U.S. immigration. Among the most controversial actions taken by the Trump administration is the revocation of protections for foreign nationals under temporary protected status. In particular, the recent decision to revoke TPS for over 600,000 Venezuelans has drawn significant attention and criticism. This status had allowed Venezuelans to remain in the U.S. legally and access crucial services, such as employment authorization and work permits. Trump's decision to end these protections is consistent with his larger immigration goals, which include reducing the number of individuals allowed to remain in the U.S. on a temporary basis. Wider implications for immigrants: uncertainty and fear amid growing enforcement. The suspension of key immigration forms and the cancellation of temporary protections have sparked widespread fear and uncertainty among immigrant communities. Many individuals who were previously relying on parole programs or family reunification channels to regularize their status in the U.S. now face significant barriers to legal entry or status adjustments. The USCIS's decision to pause the acceptance of the I-134A form has created a precarious situation for those who had been depending on the humanitarian parole program to gain entry into the U.S. This policy shift is occurring at a time when the federal government is also intensifying its efforts to conduct mass deportations and detentions. These operations have added to the climate of anxiety and instability felt by immigrant communities, who now face an increasingly hostile and uncertain legal environment. With Trump's administration pushing forward with its restrictive immigration agenda, many immigrants in the U.S. are now navigating an uphill battle to secure legal status, whether through family-based petitions, humanitarian parole programs, or other immigration pathways. In conclusion, the recent suspension of the I-134A form and other related measures mark a significant turning point in U.S. immigration policy, reflecting President Trump's commitment to reducing immigration and securing U.S. borders. These changes will have far-reaching consequences for millions of individuals who have relied on the U.S. immigration system for refuge, family reunification, and work opportunities. As the country moves further into this new era of immigration restrictions, immigrant communities are left to face the uncertain outcomes of an increasingly complex and harsh system. Trump's major reforms to Green Card adjustment of status processing times in 2025. The Green Card process, which allows eligible individuals to adjust their status from a temporary visa holder to a lawful permanent resident, is facing substantial changes under the Trump administration. These shifts could lead to longer waiting periods and more scrutiny, making it essential for applicants to understand the potential hurdles ahead. What is adjustment of status? Adjustment of status is the process by which individuals in the United States apply for a green card without having to leave the country. To qualify for adjustment of status, applicants must be physically present in the U.S., typically holding a non-immigrant visa. While the process is available to various categories of applicants, whether family-based or employment-based, the processing times for these cases vary depending on the nature of the application. Processing times and delays. In recent years, particularly under the Biden administration, the process for work permits associated with AOS has seen improvements. Initially, work permits were taking over a year to be processed. However, the Biden administration reduced this time significantly, with work permits now being issued in approximately 3 to 4 months on average. Unfortunately, these positive changes may not last. As we look ahead, the processing times for both work permits and green card applications are expected to increase, particularly as new policies and backlogs begin to take shape. Currently, work permit processing times in states like California, New York, and Florida are already reaching up to 7 months, signaling a potential trend toward longer delays. The return of green card interviews. One of the most significant changes expected under the Trump administration is the return of mandatory green card interviews. For the past 2 years, many applicants have benefited from interview waivers, particularly in family-based and employment-based applications. This video has sped up the process significantly, as applicants could receive their green cards without ever meeting with an immigration officer. However, with the return of in-person interviews, the process is expected to slow down considerably. Interviews will not only apply to marriage-based applications but also to employment-based cases, leading to longer processing times across the board. As a result, applicants may face a more prolonged wait before receiving their green card. Increased requests for evidence. Along with the return of interviews, another consequence of the shifting policies is the anticipated rise in requests for evidence. Applicants may be asked to provide additional documentation to prove eligibility, including financial documents or evidence of the authenticity of a marriage. This could lead to delays as applicants work to gather the requested information. In some cases, applicants may even be asked to attend a second interview to clarify or verify the provided documents. The increase in RFEs will not be limited to family-based petitions. Employment-based applications are also expected to face more scrutiny. Additionally, consulates and embassies, particularly in countries like Nigeria, have already begun piloting a program where applicants are being interviewed multiple times to ensure the legitimacy of their claims. How to prepare for the changes. The changes coming in 2025 mean that applicants need to be more diligent than ever in preparing their green card applications. Delays, additional requests for evidence, home visits, and mandatory interviews are likely to become more common, making it essential to submit complete, accurate, and well-documented applications from the start. It's also crucial to act sooner rather than later. Given the potential for increased delays in the coming months, applicants should consider submitting their adjustment of status applications now while the processing times are still relatively predictable. Those who delay their applications risk facing even longer wait times as the changes take effect. In conclusion, the upcoming shifts in green card adjustment of status processing times under the Trump administration will likely lead to longer waits, increased scrutiny, and more paperwork. While the green card process may become more challenging, applicants who are prepared and act quickly can still navigate the changes successfully. The video of key forms and extended processing times reflect a tightening of U.S. immigration policies, presenting new challenges for immigrants. Staying informed and prepared will be essential to navigating these changes in the coming years.